Hello, my name is Dylan Lankevich, and today we'll be talking about the case of Louis Vuitton versus Hot Diggity Dog. In this case, we have an example of a plaintiff, Louis Vuitton, filing a suit against a defendant, Hot Diggity Dog, for trademark counterfeiting, trademark and dress infringement, trademark dilution, and copyright infringement. Hot Diggity Dog is a Nevada-based pet supply manufacturer that parodies luxury brands into pet toys. The company is known for its Jimmy Choo, Sniffy & Co., Dog Perignon, and the product in question, its Chewy Vuitton plush toys. Louis Vuitton is a French fashion house founded in 1854. It is known for its signature LV monogram, which appears on most of its products, which include leather goods, accessories, and jewelry. The situation and legal contention. As stated earlier, the suit being filed contains a litany of alleged offenses. For example, trademark counterfeiting, when an actual trademark is placed on a product or associated with a service that is not the legitimate product/service offered by the trademark owner. We also have trademark and dress infringement, which relates to intellectual property and refers to the characteristics of the aesthetic appearance and packaging which signify the source of the product to consumers. We also have trademark dilution, which is when a trademark law that gives owner of the trademark the right to forbid others from using that mark in a way that lessens its uniqueness. And finally, we have copyright infringement, which is the use of works protected by copyright law without permission. In order to prevail on a trademark infringement claim, the plaintiff must establish that the mark in question is protected by the Layham Act, also that the defendant used the mark without the plaintiff's consent, and that the mark is likely to cause confusion of affiliation. The court ruled that the toys were not likely to confuse customers. To be favored for a dilution claim under the TM Dilution Revision Act of 2006, the plaintiff must first own the famous distinct mark, then the defendant has to have used a mark that dilutes the famous mark, and finally, a similarity between the defendant's mark and the plaintiff's mark must give rise to an association that is likely to impair the distinctiveness of the plaintiff's mark or harm its reputation. The court ruled that this claim in favor ruled of the defendant. To establish a claim for dilution by tarnishment, the plaintiff must show the defendant's use of its mark harms the reputation of the plaintiff. While the plaintiff contested that a dog could choke on a Chewy Vuitton toy causing tarnishment, the court ruled that there was no tarnishment because the plaintiff provided no record to support its assertion. How it applies to communications. The purpose of a parody is to imitate with a deliberate attempt to exaggerate the original work for comedic effect. The act of creating parodies is prevalent throughout mass communications. From Weird Al to sketch comedies, there is a high chance that many of us have been exposed to this method of entertainment. For a parody to exist, it must be protected beyond the media sphere. This case showed that parody can contend with large companies outside of media. Also, in an age where intellectual property is more heavily guarded than ever, it's refreshing to know that we can still legally make fun of things. Its significance. This case concluded that a parody is not a defense to dilution, but a successful parody changes the approach to the 6 dilution factors mentioned earlier. This case was a good example of the new parameters set forth by the TDRA and revised by the FTDA. This states that the plaintiff needs only to demonstrate the defendant's mark is likely to cause dilution. Also mentioned is the term famous marks are only limited to those that are widely recognized by the general consuming public. Key conclusion. In conclusion, the Fourth Circuit held that the toys were a successful parody of the plaintiff's handbags, trademarks, and trade dress. The court found that the toys are irrelevant and intentional representation. No one can doubt that the defendant's toys are not the idealized mark created by the plaintiff. The court described the differences between the products. They stated that Chewy Vuitton is a dog toy and not an expensive luxury Louis Vuitton handbag. Also, the toy is smaller, plush, with all its designs differing. The design of the dog toy is crude and simplified and not detailed and distinguished. Finally, one must buy the toy from a store that offers it. You cannot buy this toy in an exclusive Louis Vuitton store or at an expensive boutique. With the satire being unmistakable, the court ruled that the dog toy is a comment on the rich and famous, on the Louis Vuitton name, and on materialistic consumption in general. This concludes my examination of Louis Vuitton versus Hot Diggity Dog. Thanks for watching. Hey! Thank you. I feel like yours had a lot more information than mine.